Hello, and welcome back to Coin Lady channel. Shark Tank investor Mark Cuban agrees with attorney John Deaton on a key issue in the SEC versus Ripple case. In reality, Mark Cuban responded to attorney John Deaton's recent thread, added his 2 cents, and ended up retweeting Deaton's original tweets. As I record this, the retweet of attorney John Deaton's words has now been watched an unbelievable 2.7 million times. As you can see on your computer screen, Mark Cuban does, in fact, have 8.8 million Twitter followers. In that light, perhaps it shouldn't come as much of a surprise. Even if we were to have expected such a large turnout given his local celebrity, the figure would still be astonishing. So, this is aiding in the dissemination of information. That's what you call a team effort. Mark Cuban is undoubtedly informed of the status of the SEC suit against Ripple. I will explain the background and circumstances of John Deaton's, an attorney, message to you. It's all quite exciting. However, it is important to note that I come from neither a legal nor a financial background. Nothing I say or write should be taken as recommendations to purchase or sell any particular security. I'm just a fan who occasionally posts videos to YouTube discussing random crypto-related things for kicks. And if you don't like it, you're free to go. Here, therefore, is what lawyer John Deaton had to say, to which Mark Cuban eventually replied. First, I'll explain this, and then I'll show you what Mark Cuban has to say about it. So, this is what lawyer Deaton has to say. He stated, notice, as everyone knows, Gary Gensler and the SEC sued Coinbase and Binance Us just like the Ripple case. According to the SEC, it filed the suits in the name of cryptocurrency investors, users, and holders. The SEC says it exists to safeguard the general public. Do you trust Kim Jong Gensler, the SEC's dictatorial leader, to keep you safe? Do you trust that you'll be safe because of what he's doing? Is it helping or hurting your financial situation? If the SEC's stated purpose of investor protection and assisting with capital formation is accurate, then why aren't we seeing evidence of these things in practice? Deaton, the attorney, continues. Prior to the SEC's approval of the acceleration, Coinbase filed for it. It had to decide for sure if the listing was actually good for the public. And, in passing, so, I've witnessed some individuals push back, and I like the dialogue that has ensued. Don't get me wrong, I have nothing against the expression of differing opinions, especially amongst legal professionals. It's fascinating to me, but I've seen lawyers, some of whom I've highlighted, who make the case, and I'll be expanding on that in a future video. Probably quite a bit of nuance can be extracted from that. This isn't really relevant to the video, but I'll throw it out there. Some lawyers are claiming that the IPO paperwork Coinbase submitted was not meant to establish whether or not trading cryptocurrency is lawful. Therefore, there is a call for the SEC to be exempt from such regulations. This, on the other hand, seems completely false to me. That is an argument I cannot accept. It's fine for people to express their genuine opinions and have respectful disagreements, as long as they do so here. However, once again, the SEC had to decide whether or not granting approval was in the public interest. But how could it be if they haven't done their homework to determine whether or not the vast majority of Coinbase offerings constitute illegal securities? Right. What gives? This doesn't make any sense at all. Plus, that's not something you need a law degree to grasp. The SEC contends it is in the public interest to permanently shut down Coinbase, attorney Deaton said, 2 years later. In the Ripple case, I submitted an amicus brief on behalf of 75,000 plus XRP holders. Attached for your convenience is the amicus brief. Note that I am not arguing for Ripple as an amicus, but rather opposing the SEC's move for summary judgment. Ripple wasn't defended by us. We did not take a stance on whether or not XRP sales by Ripple broke any securities regulations. We argued that XRP, like Bitcoin and ETH, is simply another form of digital code. Tokens are not securities in and of themselves. Furthermore, even if Ripple did something illegal, secondary market sales would not. It's worth noting that I agree with Attorney Deaton's stance on this. His efforts are unquestionably directed on safeguarding XRP investors. Right? If you and he are both doing that, your message needs to be clear and concise. If he had abandoned the cause and begun advocating for some Ripple cause, then, let's face it, Ripple is armed and ready. Thus, I find the Attorney Deaton's argument here to be rather compelling. And so, I guess we'll have to wait and see. The final chapter in this case has yet to be written, but I am confident that decades from now, when this matter is studied by legal minds in college and elsewhere, it will be widely acknowledged that Attorney Deaton's role in representing nearly 76,000 XRP holders was absolutely pivotal in receiving a positive outcome. But in any case, argues Attorney Deaton, the Coinbase action and the Binance complaint are similar in some respects and dissimilar in others. I am not confusing the two, I am aware of their distinctions. As I was drawing near to the Ripple case, I won't be defending any of these corporations. My expectation is that Ripple will look out for Ripple, not for individual XRP investors, as I told the judge in the Ripple case. The same holds true for Binance and Coinbase, but the SEC is not looking out for retail crypto holders' best interests. That much is certain. Aims have been set by the SEC. Just as I did with Ripple. I've created a Google survey to identify a potential demographic of people who use these services and own cryptocurrency wallets. If there is enough support, we can seek amicus status to have our opinions considered in the case. Unless required by law, your identity and contact information will not be disclosed. Once again, this has nothing to do with any wrongdoing on the part of Binance or Coinbase. They will be defended by attorneys. For some of us, the SEC's attempts to gaslight the court protecting us is a deal breaker. Then he added a link and explained that it would be permanently displayed at the top of his Twitter feed, inviting everyone interested to join in. Now, this is really interesting. Probably the person I'm most like is John Deaton. Well, I suppose it's reasonable at this time to claim that the most famous lawyer with any connection to crypto is the one who specializes in this area. To tell you the truth, it's probably true. He has therefore taken part in the library lawsuit involving the SEC and Ripple. Now he wants to intervene with Coinbase and Binance. He's only trying to protect investors the way the SEC won't. Because of this, he has been featured in mainstream media outlets beyond the realm of cryptocurrency. And it's great in every way possible. If he hadn't gone ahead and jumped in, I have no idea what the landscape would look like now. Of course, I also wish to express my gratitude to every other lawyer who has helped in any manner. But Attorney Dean is the one to call when it comes time to take legal action. And he started participating immediately. And I know there's a good explanation for why everyone in this town is so thankful. And, frankly, it's as if he's protecting us by doing the work that needs to be done. It's hard to believe that's what the SEC's job entails. We are not being safeguarded by the SEC. He's defending us against the SEC, who are trying to ruin our business. It will be fascinating to observe the subsequent events. At this point in the discussion where Attorney Deaton was discussing John Deaton's role as amicus, Mark Cuban responded to Deaton. If you'd want to read that tweet again, it's currently displayed in front of you. And Mark Cuban said this in reply to Attorney Deaton. The test for whether or not a token is being resold as a security should be straightforward. What happens to the token if the company that issued it ceases to exist? That's the end of the Howey test, by definition. Dead on. Mark Cuban is obviously quite perceptive. Of course, Attorney Deaton concurs wholeheartedly. And he elaborates on this more. Says he. Indeed, Mark. Some refer to it as Bahamas style. What would happen to the token if the company or other entity that issued, minted, or mined it suddenly upped and left for the Bahamas, never to be seen from again or involved in the project again? If it weren't a security, that is. And look, I remember back in the early days of me being a crypto, And I've been in crypto since the end of 2017, so the early days may have been in 2017. In any case, 2018 is a safe bet. However, I do recall witnessing this debate. Even back then, Brad Garlinghouse seemed to be the one who was claiming something to the effect that Ripple had simply vanished. The XRP token and XRP ledger would both persist. It would, of course. The two entities are entirely different from one another. Both use blockchain technology, but one is a firm and the other is a coin. Thus, it stands to reason that it does. If that's the case, then what the heck are we discussing in the first place? That should eliminate the need for further Howey testing. Of course it should, because the token isn't used by anyone or anything in the same way by anyone, right? It's impossible. Of course, it's acceptable if you're interested in discussing specific purchases. Go. Yes, by all means do that. When discussing the token itself, please leave immediately. Mark Cuban, who has 8.8 million followers, shared a tweet from attorney John Deaton in its entirety. As you can see, it has been viewed on this screen 2.7 million times. And that was only within the past day or so. Therefore, 2,700,000 times. Mark Cuban further on this line of thinking, highlighting the SEC's duplicity and irrationality in picking and choosing which industries to target with their vindictiveness. The following is a quote by Mark Cuban. "The SEC is seen here." Okay, I'm going to expand this to fill the whole screen. I'm not going to look at the picture he attached since I don't think it's really needed to illustrate the point. I'm just giving you the option to pause here and read that, since it's on the screen, if you'd like to. However, Mark Cuban is making reference to the screenshot you currently see. The following is a quote by Mark Cuban. "The SEC has recently made headlines by claiming that the stock loan market lacks transparency. It's important to note that they are not attempting the same thing with stock loans as they are with crypto asset lending. The stock loan divisions of brokers/banks are not being sued either. They are now in the feedback phase. The same should be done with cryptocurrencies in an effort to establish which features of cryptocurrencies constitute securities and which do not. Moreover, the optimal method for controlling the market and shielding financiers. Their distinct methods make clear that they are targeting different sectors." Tone. Because we can't read the SEC's thoughts, it's best to pick and choose which industries to focus on. However, they don't have hearts, which is why we can't. As it turns out, they're not even close to being human. They're just Satan's offspring, a bunch of spoiled brats. However, they do possess minds of their own. And I have no doubt that some truly vile things are stored at great heights. We don't have enough information to determine their motivations. But we see that they are actually doing it, and it is clearly wrong. And Mark Cuban, who clearly has nothing but contempt for the SEC. In case you missed it, he had some shady dealings with the SEC on his own. They leveled several charges against him. It is believed that he might have reached a settlement with the SEC for around $2 million back in the day. But he replies, "No, then my reputation will be ruined forever. No, I intend to return fire." It is said that he spent almost $16 million fighting the SEC, but ultimately prevailed. That's another million we easily could have used. In the end, it cost $16 million. He triumphed, though, and his possessions remain unharmed. Since he had an absurd amount of money, it was probably quite worthwhile in his eyes. However, this goes to prove that the SEC is wrong most of the time. And everything related to cryptography is crystal clear. Their entire premise is repulsive, incorrect, and harmful to others. No, I don't give out financial advice. Nothing I say or write should influence any transactions you make. Please like if you enjoyed it and subscribe my channel. See you later, bye.